Hello, welcome to another edition of Ask a Beaver Anything. Beavers Behind Enemy Lines members may recall that a while ago we did an interview with Kerry Eggers. It was a great time interviewing the interviewer, but today we have another twist. I'm bringing on with me my longtime friend, Tony Pulicella. And let me explain what the twist is, then I will introduce Tony. So, with Kerry Eggers and hopefully with other editions of Ask a Beaver Anything, I get to ask the questions. However, today with legal news in the sports world in the Pac-12, people have been asking me questions. So I've invited Tony on to ask me questions for you, the questions that you probably have on what all this means for Oregon State, the Pac-12, and I appreciate Tony doing it. Now, Tony, as you can tell from his attire, is an Oregon State graduate, graduated in the 80s sometime, I am told, sometime in the 80s. I too am an 80s graduate, but it was a lot earlier in the 80s than Tony. Tony, is it fair to call you a sports fanatic?
100%, especially when it comes to OSU athletics and college sports in general.
And certainly an Oregon State fanatic. And Tony is working with a digital marketing company called Engaged Nation. And so he probably knows a lot more about streaming stuff and online stuff and live streaming than I do. But it's my show, so we'll do that. So, perfect. Tony, ask away. What do you want to know about what happened today in the Superior Court in Whitman County, Washington?
So thanks for having me on as becoming your questioner and you're being the questionee and getting to tap into that vast legal knowledge that you have just oozing out of your ears. So as we found out today, much to many of our surprises, that Washington State and Oregon State jointly filed a injunctive relief against the Pac-12 to block a meeting, I believe, coming up that was scheduled outside of Mr. Schultz's authority out of Washington State, and then also for the court to determine, I believe, who owns the assets of the Pac-12 with 10 schools leaving it. I'm hoping I got that right, Alan.
Well, it's close. And one of the things we talked about off air before we started recording was Athletic Director Barnes and President Murthy have been receiving a lot of criticism on message boards and other places, including Beavers Behind Enemy Lines. And I have happened to know that they were working on a lot of stuff behind the scenes. And today's filing, I think, demonstrates that. A filing like that doesn't just happen in a couple of days. And it takes a lot of work, and they have been at it. So, yes, this is an injunction. And at an injunction, there's three different stages. There's the temporary injunction, the preliminary injunction, and then the permanent injunction. And what happens is at different points in time. And typically the temporary injunction is to freeze everything in place as it is to until other issues have been solved.
Now, if I'm not mistaken, they got their court date and time for 11 a.m. Monday morning. Am I correct on that?
I have not been able to confirm that, but I have seen references to that. So the temporary restraining order typically is just the party that is moving for the injunction. And they say, now here, because of the significance of everything, they have probably, they have set this hearing to allow other parties to intervene. And then after the temporary, usually a temporary lasts for a week, 10 days, short period of time to allow the other parties to intervene and to have a more thorough hearing.
Now, when you say intervene, that's a fancy way of saying responding to the injunction?
Responding is a much better word, actually. But it gives them a chance to appear before the court, to provide written briefs, and to make arguments both in writing and verbally, either in person or these days. Oftentimes it's done by video.
Okay, so now let's just go on the assumption for a second that that the judge gave them an 11 a.m. Monday hearing on this preliminary injunction, correct?
Correct.
Preliminary. All right. So that means either in person or through Zoom, Skype, whatever the heck it is, right? All parties show up. Is that correct? Or is it just Oregon State and Washington State representatives and the judge, so that OSU and Washington State say to the judge, here's why you need to give us our temporary preliminary injunction, and then it's just the three of them? Or what happens at 11 a.m. on Monday morning?
Good question. And the answer really is, I don't know. It could be either of those things. I just haven't seen enough yet to determine that. Typically, the temporary injunction is just the moving parties. But in some instances, the courts can say, yeah, I want to hear from everybody. Okay. And I suspect this will be, we want to hear from everybody. And that is what's going on Monday. But I don't know for sure. And hey, I probably should have led with this. I am an Oregon lawyer. I am a lawyer. But I want to throw out a disclaimer here. Is I know all I have done is read some press reports and have read the documents that have been filed with the court. I know absolutely nothing factually. I don't have any inside information, and I just have my opinions based upon what I have read. And I also
your knowledge of the process more than anything
knowledge
else.
Of the process.
Right.
Also, too, I'm an Oregon lawyer, and so this is filed in Washington. And to the extent that Washington law differs from Oregon law, I'm not knowledgeable about that either.
So Nick Daschle of Oregon Live is reporting that it is set for 11 a.m. in Whitman County Superior Court. So just throwing that out there. So let's just play this out a little bit. So you're saying it could be either one. It could just be OSU and WSU, their reps, their legal team goes in front of the judge and says, here is our filing, which it was 16 pages of, as I looked at the document a little earlier, their grievances were 16 pages long in the actual full filing, with the restraining order request being 2 pages long. I guess that's probably makes more sense, right? You've got your one document that lists all your grievances and problems and why, and then you have your separate document that's just the request to hear it, I guess is the question. Is that right?
Well, and there's one other document that you've missed.
Oh, okay.
And that is, and I'm checking the number of pages here. I think it's about, I don't know, 17 or 18 pages, the memorandum of points and authorities. So this memorandum is their argument, their written argument.
Okay, thank you.
If, as I said, my guess is they'll have everyone there. If not, representatives of each of the other 10 programs will certainly be in the back of the courtroom, and they'll be raising their hands and asking the judge if they can contribute something. My guess is that over the weekend, there will be lawyers who are very busy, billing billable hours for the 10 respective schools.
Sure.
And that they will be filing papers with the court before the 11 o'clock hearing.
Right. Now, you'd have to think, and obviously those of us that are just your typical fans that have been grousing about what we appear as the lack of action, right? Whereas you thoroughly dismissed that and said, no, you can't just put all this together in a day. So even though we found out a couple of days ago, or maybe it was even yesterday, who this legal team was that OSU had hired, obviously they'd hired them a heck of a lot earlier than when it got leaked who they were. And same thing, I'm assuming, with the team that Washington State hired. They've all been working together. It's because it's a coordinated effort. And that clearly must have started weeks ago. Now, conversely, especially when you consider the institutions we're talking about, we're not talking about directional colleges in the middle of nowhere. We're talking about Stanford, USC, UCLA, right? So what UW, these are big schools. You'd have to think that their legal teams were racking up billable hours, already having their counter arguments ready to go. Wouldn't you think that they say Oregon State and Washington's going to do this? If they don't, they're crazy. And if they don't, great, we win. We'll get an even share. But if we know that they're going to fight it, at some point they're going to fight it. And so we have to be ready for their argument, whether they file it or not. Does that make enough common sense?
Well, you would think so. Although don't ask me to guess what academics are thinking about. So
it's true.
With some of these universities, there is a certain amount of institutional arrogance, and we don't need to mention any names, but
I think we all know it.
But I am sitting here behind enemy lines, and if you look at the paint on the walls, I have orange walls in my office.
Glorious, man. That's glorious.
So
now I'm behind enemy lines down here in Vegas. But, they don't tend to be too, I'd say it's more detente than anything else. I think we're all a lot of us folks are kind of becoming kindred souls. I mean, you look at the folks online, and I know we're veering off here a little bit, but, Wyoming, UNLV, all us, the Mountain West guys, Washington State and Oregon State, all of a sudden we're the band of brothers. And then other schools across the country are supporting us and Washington State, because we are getting left out in the cold. That's a whole nother discussion that we can have. Let's go back to the legal. Now, we can make our assumptions, whatever. Monday, let's say it's 11 a.m. OSU, Washington State, they present their argument to the judge. If these other schools had half a brain, they were already forecasting this, and they're there, that they're able to get in. Now, that's assuming that they're allowed. There is an option you mentioned earlier where it's just the judge, and he just hears from Oregon State and Washington State and their 16, 17 pages of grievances and says, you know what, there's enough here that I'm going to pause everything. I'm going to put this temporary hold on any proceedings at a conference level until things can be sorted out. And then, having been through a couple of legal things in my past that you were so kind to help me through, nothing illegal, but there is an opportunity then, and I'm sure anybody that knows this has been in legal stuff. You make your case, you file your case, then the defendants, if you will, I'm assuming they would be considered defendants, they get a certain amount of time to respond to the allegations or to the claims that Oregon State and Washington State are making. Is that safe to assume? That's
right. So if a temporary restraining order has been granted, then deadlines will likely be established for a response from the defendants, and then a further reply from WSU and OSU.
Right. So they get to reply to the reply.
They get to reply to the response, right? And then a date will be set for a hearing on the preliminary injunction. Now, when you're in a preliminary injunction, in Oregon, this trial would probably take place in 9 to 12 months.
Which in this particular case, we got to figure there's going to be some expedited dates on this just because of the sheer nature of the situation. Correct?
Well, but the 9 to 12 months would be for the permanent injunction, not for the preliminary injunction.
Okay.
And in Oregon, I learned last weekend that at least people in California, they consider Oregon to be a rocket docket. So that in California, it might be 2-3 years before a case goes to trial. So
Wow.
Oregon is considered very fast. I don't know about Washington, but as you were alluding there, all the marbles are for the preliminary injunction. That is where the case will be decided. I suspect on Monday, it starts at 11. They'll break for lunch at some point. They will probably go all afternoon on Monday. The hearing for the preliminary injunction, there will be discovery, depositions will be taken.
Wow.
And
all of that on Monday, you think?
Well, no, on Monday, after Monday will be when the depositions are taken.
Understood.
And it will probably be in a week or two that they'll take depositions of the Pac-12 commissioner. They'll take depositions of a number of other people. And then they will come in for this hearing. But this preliminary injunction hearing will be the case. When they decide that, and that probably will be in a few weeks, but when they have that hearing, that probably will resolve everything.
So not the Monday meeting.
Not the Monday.
The one that happens in a couple of weeks.
Yes.
Wow, that's fast.
Yes, and it needs to be fast, quite frankly. And Oregon State and WSU need it to be fast. But a couple of other things may happen. And that is the other defendants may say, and by other defendants, it's everybody other than the University of Washington and the University of Oregon. And I'll explain that in a moment. But the other 8 could bring a motion that says, now we don't want to litigate this in a Washington courthouse. And in fact, we really don't want to do it in Whitman County, which is the county where WSU is located.
Bias.
And so in our judicial system, we have both state courts and federal courts. In federal courts, you only get to try cases that are based on federal law, except when there's what's called diversity jurisdiction. And diversity jurisdiction is when, Tony, if you were to sue me, you live in Nevada, I live in Oregon. If you were to sue me in Nevada, I'd say, I don't really trust the courts of Nevada. I want this to be in federal court. Now, diversity jurisdiction, though, can get complicated very quickly. Oregon doesn't have a claim. Well, let's take Oregon back for a moment. Certainly, the University of Washington would not have a diversity jurisdiction argument
because they're in the same state.
Because they are in the same state. They're in the state of Washington.
Okay.
Now, I am not up to speed on all the ins and outs of diversity jurisdiction in federal courts, but there could be an argument that because you have a Washington plaintiff, WSU, and you have a Washington defendant, University of Washington, those two cancel out. So there is no conflict. And I believe a federal court could say, no, we don't want to hear that.
Wow.
These are not issues. These are not issues I've researched. I am a business attorney. These aren't questions that I've ever been in, kind of digging back to the days of law school. But
sure.
when talking about what you should be looking at in the future, that is something to consider. I have been in touch with a lawyer from WSU. He graduated from WSU, but like me, he practices law in Eugene.
Okay.
And he has had a lot of experience with the University of Oregon Legal Counsel's office. And he has some suspicions about certain things. But we will leave that to him.
Okay.
But I guess he he's a little worried that there might be some folks in the green and gold who are looking at all the different ways they can stick it to Oregon State.
Well, there's no question. I just as a, granted, I'm a partisan, but with everything that's taken place, there's been no thought whatsoever to member institution like us. It's been in the same state, the rivalry, everything else, that any relationship that might have been there was chucked the moment that they bailed on the meeting and decided to go to the Big Ten with UW.
So you look at USC. USC sticks with their rival UCLA,
right? Zona. Yeah.
Arizona stuck with Arizona State.
Yep.
Stanford stuck with Cal.
Yep.
The only traitors to their in-state rivals were UW and the University of Oregon.
That's right. They didn't care about it at all. Now, and I've seen people that say, well, if the roles were reversed, you do the same. I'm not so sure about that. I really am not. And it's just a different mindset.
Well, not only do I not think it's true, but I have argued that if Dave Frohmeyer were still alive and if he were still the president of the University of Oregon, none of this would have happened. Oregon never would have bolted. Washington then wouldn't have bolted. Arizona State, Stanford, Cal, they all would still be there. Utah, Colorado might have bolted just because Dion wanted to go. But
I think there was a fait accompli. That's fine.
Yeah, but who cares about Colorado?
No, I agree with you.
Who cares about Colorado? So anyway, but Dave Frohmeyer, native son of Oregon, Rhodes Scholar from Oregon, bright guy. I think he would have put the interest of the state first. I think he would have put the interest of student athletes first. And maybe I'm wrong, but I knew Dave. Dave was a mentor at different times. And I don't think he would have done that. So when people say, oh, you would have done the same, it's like, no, even your former leadership would not have done the same. So I don't think that's right. Hey, let me get to a couple of the factual points that have been alleged.
Yes, please. And I was going to ask you a couple of projections as well. So please.
So, all I know is what has been alleged in the pleadings I've read and statements made in the media. I have these documents that have been made public, these court filings, they refer to exhibits such as the conference bylaws, but the conference bylaws are not included with what's been made public. There's also been a number of declarations. So that's factual information. Someone says, hey, these things happen. I declare it under the penalty of perjury. Think of it as an affidavit.
Right.
And those aren't attached either.
Right.
But what it is alleged is that the commissioner of the Pac-12 has called a meeting when WSU and OSU refused to do it. They called a meeting of all 12 schools to vote on a retention package for Pac-12 employees and talk about governance on a go-forward basis. Now, I hate the go-forward term.
Okay.
That became popularized in corporate circles about 4 or 5 years ago. Some consultants somewhere used that as part of a proposal, and everyone's been using go forward as a term. That's a pet peeve. But
all right.
Oregon State, WSU said, hey, wait a minute. There's only 2 voting members left. Well, that then gets us into the question of notice. And it is reported that the bylaws say that once you give notice, you're no longer on the board. You're out of the club. Well, what does give notice mean? And that's probably going to be a big point of the argument. That's probably what it's going to turn on. Well, let me tell you about notice legally and other context.
Okay. That's a great point. And because as I'm sure you're going to say, there is you walking into your boss's office and screaming, I quit, versus you sitting down at your computer and saying, I, Tony Pulicella, as the Chief Marketing Officer of Engage, do hereby resign my position effective, blah, 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 blah. Sincerely yours. Stick it up your butt. Bye. And that is also a notice, right? So I think you're going to tell us the difference here, right?
Well, and by the way, in case anyone was wondering, and Tony said that he and I had worked on some things, we never worked on anything like that. So I've never represented Tony in such a case.
No.
Purely hypothetical. So notice comes up in the law all the times, and there is different types of notice. And usually any type of notice is adequate. So there's actual notice. There is constructive notice. There's implied notice. And implied means either you knew or you should have known notice. That's what implied. Even if you didn't know, you should have known, therefore you have notice.
Okay.
So usually notice isn't a big hurdle to overcome.
Right.
And not only that, but here,
4:57 p.m.
oh, Siri's acting up on something over here. Excuse me. So, but here they also have their course of conduct, and course of conduct can provide interpretation into what type of notice it is. So Stanford, Cal, they said we're or not Stanford, Cal, excuse me, USC, UCLA, they said we are joining the Big Ten. Well, guess what? They never informed the conference they were doing it, but they informed the media.
Well, yeah, they went on Twitter. They went everywhere. Social
That's
media,
right.
everywhere. They put out nice, fancy graphics with them, with the Big Ten logo. The Big Ten welcomed them to the conference and all that kind of stuff. And the same thing happened.
Digital marketing people were involved.
Exactly. And then you got the same thing with Colorado. And then everybody else that did it. It was the three more that went to the Big 12.
Well, here's what's important. Here's what's important about USC and UCLA. As soon as word got out, the Pac-12,
right,
the remaining 10 members said, "Boom, you guys are off the board."
Right.
Okay. As soon as Colorado left, boom, you guys are off the board. And now they're saying
they've had meetings, and there's been precedent, right?
Yes.
So not they whether they did it verbally, written, whatever, or they just called up and said, you're done. There's been board meetings since that they weren't part of, so there was precedent set, right?
Well, it's actually a pattern of conduct.
Pattern of conduct. Thank you.
So this must be what the bylaws means, because this is how everyone acted in those instances. And USC and UCLA, they didn't file a lawsuit that said, no, we haven't given our notice yet, so we still get to vote. Colorado didn't say, no, we haven't filed our notice yet, so we get to vote. No, we haven't seen any of that.
Right.
So because notice is generally easy to establish, and because there's been a pattern of conduct, I would have to think that the notice argument, and people are going to argue, and you argue over what you have to argue about.
Sure.
But I think that's going to be the question that turns on it. And I would think, without knowing more, without having actual information, without actually having read the documents, but I would think they would have a pretty good case.
Now, let me throw this out, because we take a couple of steps back when you were explaining the progression, and this was something that's been laid out pretty well on social media as well. Schultz at Washington State, after everybody defected, and it was just Oregon State and Washington State, became chairman of the board de facto. He became that guy because, I guess it's implied or whatever, because Klavikoff, or however you pronounce his name, requested that Schultz set up the meeting with the rest of the schools. Correct?
Yeah,
and Schultz said, "No, I'm not doing that." And then GK went around his back and set it up anyway.
Yeah.
Am I right about that?
Yeah, this is going to get a little deep in the weeds in what the bylaws provide for, bylaws that we haven't seen.
Sure.
But it may go to the pattern of conduct is, wait a minute, they treated it as if there were two board members, and now they're saying there's not. Yeah.
Just the simple fact, what I was getting to is just the simple fact that GK asked Schultz to set up the meeting implies that he's the main guy for the board, because the board is the CEOs. Is that right? Is that how it works?
The presidents of the university.
Okay.
So there is a committee of the board, I believe, which is called the CEO group. Right. And so instead of working with 12, they worked with 4 or however many were at that. And so that's what the CEO group is. Okay. But yeah, it's so George K has been a disappointment in a number of different ways.
Right.
He has a fiduciary duty to the conference. Well, who is the conference?
Oregon State and Washington State right now.
I don't think it's the other 10. They're not part of the future of the conference. He has a fiduciary duty. Oregon State and Washington State has been trying to get information, and people are fussing at
right.
People are fussing at Murthy, and they're fussing at Scott Barnes, but they can't get the information out of the conference.
We found out today, I believe, that the legal teams requested the information from the Pac-12 lawyers a month ago.
Yeah.
And they haven't they haven't replied yet, other than to say we're working on it, right? I mean, there's been a clear delay tactic, it seems, from the Pac-12 offices.
So as soon as it is established who is the board, and if it is found that the board is Oregon State and Washington State, and this could come out as a result of the preliminary injunction hearing, which I assume will be in a few weeks. I know what my very first act would be, and that'd be to fire George K. with cause for breach of his fiduciary duties, no severance.
That would be glorious. I agree with you. I think that's step one of a scorched earth approach that Oregon State and Washington State should take. So because they have been left out in the cold on this. So
would you bar the other 10 from conference championships?
We see, now I'm a jerk, right? So I'm a vindictive jerk in so many ways. I guess it was a little bit of the Italian in me that and I think Canzano probably, I think he recently used the term going to the mattresses, which is exactly what they should do. I would maybe not that far, but I guess it would depend on how big of a pushback you get from the 10 schools. Now, look, they have to know. Okay, well, let's take legal out of it, right? As the old expression goes, you can indict a ham sandwich. Legally speaking, they can fight this thing and tie it up for 10 years if they wanted to. Publicity-wise, does it make sense to do that? Don't know. The question I have is, how bad are they going to push this issue? If the judge, like you said, within 2 weeks, I'm certain, as certain as anybody could be, there's enough evidence just in public domain, let alone whatever else Oregon State and Washington State can provide the judge on Monday morning to grant that injunction. All right, everybody take a breather. Nobody gets to do anything. There will be no board of directors meeting of all 12 schools. There will be nothing that takes place. Everything freezes, like you said. And then you're going to have 2 weeks later. Now, if we get to the 2 week period, I'm just throwing this out, and that's where you said that's ultimately where it's going to be decided. In that, after that discovery and the replies back and the so forth and such and such, they get together in 2 weeks where they do their depositions and all that kind of stuff. That's when it's really ultimately is going to be decided. If the rest of the schools take it and say, okay, fine, you win. I don't see Oregon State and the presidents and ADs. they're upset, but they don't seem to be like the kind of person I am, where I would say, you're right, you're out. Oregon State and Washington State, congratulations. It doesn't matter what happens the rest of the season. You're playing in the Pac-12 championship with a shot to go to the thing, and you guys don't get to go to any bowl games or any of that. You could do that across the board in all sports. I don't see them doing that. I could also say that I don't see them necessarily denying them some money that may be part of this year's funding and so forth like that. I don't see that. I don't see them doing it. Personally, I would, but that's me.
Well, here's a reason why not to, Tony. So obviously I have thought about these things as well. But Oregon State has a legitimate shot at being the Pac-12 champ in football.
Agreed.
And I think every other school, there's probably 4 or 5 other schools that have a shot if they keep their quarterback healthy. Wow. Oregon State, you lose number 1. We've got 2 and 3 who both look really good. So that helps our chances as well. You wouldn't want to have Oregon State win the Pac-12, but have an asterisk by its name.
I agree. And again, that's just me being a super fan
I'm also
really
told,
upset with these guys.
I'm also told that we have great new infielders coming in for Oregon State baseball.
They're looking strong.
And Oregon State may have an opportunity for a Pac-12 baseball championship as well. And you wouldn't want to put an asterisk behind their winning that.
And ladies basketball is definitely on the back, bouncing back. A lot of good talent. So I agree. I think our teams can prove it on the field, and I agree. Besides, they would want the teams to, assuming for a second, we still have through this season, 6 bowl tie-ins. We're going to want to send those teams, the teams to those to the bowls to get the revenue from those. Now you can say you're going to get your expenses covered, but you're not going to get any profit because that doesn't come back until 25 or whatever. So there's some things that they could play around there, but I agree, Alan. I don't see the presidents and ADs going that hard a line. But again, I do believe a lot of that has to do with how the other 10 schools respond.
Well, I agree with you totally. I think there's leverage there. I think there's also will be an opportunity for a settlement. And so hopefully that will happen. I have a proposal for you, Tony.
Oh, please.
This was fun. Let's do this again, possibly next Tuesday, after we know what happened in the courtroom in Whitman County, Washington on Monday. You game?
Count me in. Pencil it.
All right. Tony, thank you. Thanks for reversing the roles here. And I will be at the game on Saturday cheering hard, and we will cheer for you.
Thank you.
Even though I know you're at home watching it, if you want to text me, I will reply. If the text gets through, sometimes it's hard to receive communications with everyone on their phones at the same time at Reser.
Well, thank you, Alan, for having me. It's been a blast. I'll do this anytime. And yeah, I will be living through osmosis.
Hey, good to see you, Tony. And I hope to see you in person in Las Vegas for the Pac-12 football championship.
You can count on it. Thanks,
and I'll see you Tuesday.
Okay, bye-bye.